when we drafted the blog post, Peru's in Peru's case, the regulations were still a draft, but they have recently been adopted, so they are official now. And so in this next few minutes, we will try to capture the trends that we're seeing, the commonalities and the disparities among these proposals, and see how this is influencing the development of AI governance in the region. Today, I am pleased to be joined by FPF's Senior Fellow, Pablo Palazzi. Thank you, Pablo, for being here. An extra thank you because it was
Thank you,
Pablo's
Maria.
birthday yesterday, of
Yeah.
course. So an extra thank you for being here today on a Friday. Pablo is also a partner at Allende Brea, a law firm in Buenos Aires, where he practices data protection and internet law. And today he will be joining us to provide a little bit of more insight into the discussion as an expert being in the ground. So welcome, Pablo. It's
Thank you.
really good to have you as always. Okay, so I will like to start by framing this discussion and perhaps highlighting a little bit of why we wanted to do this research. So at FPF, we noticed that there were a lot of proposals that were emerging in this region. And of course, this is a trend that is happening or that we're seeing in other regions as well, or worldwide, with the widespread adoption of AI technologies. However, we saw that it was particularly interesting in the case of Latin America because first, we're seeing that there are a lot of proposals in the region. So in Latin America, there seems to be a particular interest from lawmakers to propose AI legislation or AI regulation. And they have consistently, through several legislative periods or legislative sessions, introduced some AI proposals, and some have been successful of staying there while others have not. So for instance, Colombia and Mexico, they have 3 and 4 respectively bills that are under review, but in previous legislative sessions, they have already like archived other proposals that were very similar in terms. So this is one reason. And I believe the other day, Pablo, we were seeing that there might be, like, some are saying that there might be even like 400
Mm.
proposals in the region in
Mm.
total,
Yeah.
that in a way they touch upon AI or that intend to be comprehensive frameworks for AI regulation. Um, so I wanted to mention this because I believe it does signal, in one hand, like a great interest from policymakers in Latin America to regulate AI, but at the same time, it could also signal a little bit of fragmentation or a little bit of disagreement on exactly on how to do so. And the second reason we wanted to make an overview of these bills is because we noticed that most of them seem to have a very like a big influence from the European Union's AI Act, in the sense that most will have or are proposing a risk-based approach, and they include provisions, for instance, for prohibited AI systems, and very similar terms in sense of scope and definition of AI. But at the same time, these proposals also include like their own flavor. They have like their own adaptations in other provisions. So we are not exactly seeing a case of copy paste legislation that tends to be the what happens sometimes with EU and Latin American proposed legislation. And on the contrary, we're seeing that some of these bills have very particular provisions that are aware of the context or the necessity of each of these countries. So for instance, a very particular case that comes to mind is that in the Mexican bill, it does have a very similar definition of high-risk systems, or systems that have a high risk. But at the same time, it seems to only allow the use of these systems for public entities and the armed forces. So this is a very, like, trying to be like a similar approach to the EU, but at the same time they like going in a very different direction in the end. So Okay, so what are like the commonalities or the key trends that are we seeing in these proposals? So first of all, I would say principles and rights. We see that most of these proposals are heavily rooted in principles of human dignity, autonomy, non-discrimination, transparency, safety. Some of them also make an explicit reference to the principles of privacy and data protection or privacy by design, as is the case of Colombia's bill. And interestingly, some of these bills also include specific chapters for what they call AI rights or new rights, such as is the case of Brazil and Mexico. So, for instance, we see in Brazil's AI bill, which is one of the more advanced in the legislative review, that it has a very extensive catalog of new rights, including the right to obtain an explanation, the right to human review, to non-discrimination, or to challenge a decision that it was based on AI. Mexico's bill also have a similar a similar chapter of new AI rights, including uh, in a very innovative way the right to communicate or to use AI systems for users. Although the chapter, when we compare it to the one in Brazil, it seems to be a little bit less detailed or lacking like specific mechanisms on how individuals may ultimately exercise these rights. We should also emphasize that like all of these countries under review, they have adopted or they already have a comprehensive data protection law, which already provide some level of protection for decisions that are based on automated decision making or that do profiling. So I believe like a very interesting point, and this is something that we highlight in the blog posts. So in case if you're interested, go read that part in the blog post. I believe that whether some of these bills may eventually be adopted or not, it's important to keep in mind that all of these countries already have some level of protection against profiling or ATM in the context of AI. Pablo, I don't know if you want to briefly comment on this heavily
Yeah,
reliance on principles.
just just a little note that when you mentioned that they are following the European Union, I mean, is a deja vu of what we have seen in the data protection field in the last 20 years. All Latin American countries has adopted one way or another a general data protection bill, and is 90% based on European Union regulations, either the old directive of 1995 or the GDPR. But there are some twists, as you mentioned, because when a lawmaker start using as a model European law, they always try to put something local, and that comes up in the debate where they are drafting the bill. In the case of Brazil, I would say it's different also because the AI bill in Brazil has been subject to a 1 year review of witnesses, people invited to declare in Congress, experts, some written submission, and a huge report about what was needed in Brazil. So Brazil has a very open debate about this, which is very important.
Yes, absolutely. And yeah, I believe it's that transition, from trying to bring like definitions, like as you mentioned from in the data protection space, what had happened, of trying to bring like these EU definitions and in the end to make some adjustments or adoption, like sort of inserting that regional flavor. Just to briefly comment, do you think that has been helpful in the end, or do you believe it's been like a sort of Frankenstein that has developed when?
No, I think it's very helpful because we are building upon something that was already built in the European Union, and most Latin American countries have a civil law system, not a common law system. So it's totally understandable that they will look to Europe for regulation and not to the US, especially now that the US has floated the idea of a moratorium, which was finally rejected. But the idea of a moratorium is not an idea for Latin American countries because they have this tendency to regulate instead of leaving the market operate by itself.
Mhm. Yes, absolutely. And this is also why we're seeing that the possibility that some of these bills might come into effect and then might be adopted, and others might be also archived and be like a thing of the past. Yeah.
And I think that's very useful that they share the definition of AI system, because that will harmonize a bit the regulation of Latin America with Europe.
Yes, absolutely. That's another like a key point that we are seeing across these bills, that most of them share almost exactly the same definition of an AI system. So moving a little bit on with the blog post, what another like big area where we're seeing a lot of commonality among them is this risk-based approach, right? So most of the proposals will include some risk classification going from minimal to high risk to systems that pose unacceptable or excessive risk. Unacceptable here, a brief note is that unacceptable and excessive risk seem to be defined under the same term, or very similar terms, but they are used. I believe Brazil uses excessive risk, while the other proposals use unacceptable risk. But the way that they're proposing regulation is very similar. So some of the proposals also include the obligation to conduct preliminary risk assessments prior to their introduction to the market. This, of course, in order to assess their level of risk. And so generally we see, similarly to the EU AI Act, these 3 levels of risk, right? So most bills will have a very similar definition as well on unacceptable risk systems, meaning those that are generally considered to be contrary to the protection of fundamental rights, or that are used for the purpose of, for instance, manipulating behavior of individuals or exploiting vulnerabilities from certain groups, or for very specific use cases, such as to facilitate the use to operate autonomous weapons, or to conduct a real-time biometric identification, among other cases. These systems, of course, are generally prohibited, but we find that there are some exceptions in most cases for criminal investigations, of course, by public authorities. The second level, I would say, is high-risk systems, and this concern, well, first of all, I would say that some of the bills define these high-risk systems based on certain domains or sectors that which they might be applied to, while others have a more general or principle-based approach to on how they define these high-risk systems. So generally, this type of systems are left to be classified further by a competent authority, which I believe this gives some flexibility and some discretion from regulators, or what would be like the national AI authority, to evaluate which systems are considered to be high risk. And of course, this will ultimately depend on the level of their capacity or their likelihood to create adverse consequences for individuals. So for instance, just to mention a couple of examples, we see that in the Brazilian bill, we see that they list, I believe, like 10 criteria for further classification to be done by this AI authority for high-risk systems. And this criteria is based on the likelihood of this system to impact on essential services, public services, whether it lacks transparency or not, like the level of transparency that it provides, or whether it poses risks to health and safety, among other criteria. And then we have Peru, which is another type of regulation that includes a classification mostly for sensitive uses by sector or domain. So for instance, Peru will most likely consider that an AI system is of high risk if it is related to biometrics, education, employment, or if it's used for critical infrastructure. And we see other proposals like Colombia, which have a mix of these 2 approaches, which is not only sector or domain based, but also have like this general approach, like the one we see in Brazil. And then we have, of course, those systems that are considered of minimal risk. Um, we 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 see that fewer proposals have like specific or targeted provisions for this type of systems with limited risk. But they are there, right? So for instance, we see that Colombia generally defines these minimal risk systems or those that pose a significant threat, but that have a very indirect effects or insignificant consequences on individuals. So this might include systems that are used for personal assistance or recommendation engines, and some systems that may simulate human interaction. And generally, these systems are subject to more of like transparency obligations, uh, like I would say like fewer regulation, and in most cases, it's just about providing the users to opt the option to opt out or to provide the necessary information so that they are clear that they are interacting with an AI system and they can make informed informed decisions. Yes, Pablo, do you want to?
So yeah, I was listening when you mentioned that all these bills are adopting the approach of regulating, forbidding certain activities based on the risk that they may pose to users or to people, and that's a copy of the EU Act, and it's basically, I would say, a consumer protection regulation, because it says you're putting something in the market that can create a damage or harm to someone. So we are not allowing this, we're allowing this. And there's an overlapping with data protection, because in my view, most of the things that these new AI bills are regulating is already regulated in data privacy laws with automatic decision-making provisions. And, and a good example will be the Ecuador draft regulation that the DPA of Ecuador just put for comments last week. It forbids the use of AI system for biometric recognition in public spaces, basically surveillance using AI and image recognition. And in the end, it's something similar that you find in the bills you mentioned. So by using data protection law, you can achieve the same ends that you may achieve with this consumer protection regulation, where you say products in the market which these products are not for allowed because this or this. So it's interesting to see how the overlapping will take place, because most countries in Latin America already have data protection laws, and most of them, as you mentioned in your blog post, has provisions about automatic decision making using data, which includes AI and machine learning.
Yes, of course. And it's actually very interesting that you mentioned Ecuador's, well, I believe the DPA is the one issuing
Yes.
these regulations, right?
Yeah, it's a draft
Because
regulation.
yeah, because we are, well, I was about to jump into that other common element that we're seeing
Mm.
across these bills, which is the institutional design, right? Like the governance
Yeah.
framework of AI and who's going to be ultimately the AI authority. And what we're seeing in these proposals is that there seems to be a preference of creating like a multi-stakeholder community or structure for
Mm.
AI governance, but ultimately there's always one AI authority. And in many cases, this like the faculties or like the competencies to regulate AI are assigned to a new AI authority, and in fewer cases they are assigned to the DPA. So, for instance, in Brazil, we have seen a lot of like back and forth from several regulators on whether who should be the AI authority. I believe in the last like the last version of the bill that is currently under review, I believe the DPA, the ANPD would be the main authority, although with
Mm.
some coordination with other sectoral bodies. But I believe there has been like some pushback from other regulators, for instance, the telecommunications regulator saying that there shouldn't be like a single authority with representation as the AI authority in the country, but more of a shared like a shared authority in a multi-stakeholder or multi regulator body.
Yeah.
So it's very interesting in the case of Ecuador, which lacks, as we speak, an AI bill, that the DPA is already proposing some regulations that will inevitably like impact uh, how AI systems are regulated in the country. So I don't know if you have a little bit more insight into Ecuador's
Yes,
case.
the way Ecuador has been, the law is pretty new, but they has been enacting a lot of regulations about everything, about legal basis, about sanctions and fines, about transmission and international transfers of personal data. So they are very active. This is a draft regulation to force register AI systems in the country, and also it has the typical prohibitions, like the one I mentioned about public surveillance, use for deep fakes, etc. And the way it's framed, it starts saying we are regulating AI system when they process or collect personal data, because that's the link to data protection. So they can regulate the AI system as long as it collects personal data in the input or the output,
Mhm.
and that is processing of personal data for them. And it contains a lot of nice suggestions about how to apply privacy by design, privacy by default to AI systems. I think that's very useful. On the other side, we wonder, I mean, since most AI systems are built in foreign countries, and Ecuador is kind of a country that will use them, but probably will not create it, as far as I know. That's complicated because how do you deal with a local regulation which is different than the rest of the general regulation? So that's another problem.
Yeah. Yeah, and I was just thinking, of course, right, like the personal data will always be the link, and I believe
Hmm.
personal data is what habilitates a DPA to have some sort of
Hmm.
say, right, with AI regulation. But I was just thinking, like, as we see the development of these AI proposals across the region, where some AI, like the proposal is to have new authorities and not always the DPA being the AI authority. How do you see that developing in practice, like with the overlap of functions? And also considering the institutional capacity
Hmm.
that some of these agencies might have to be like either way, like the new if we have a new agency created solely for AI regulation, or if we have the TPA, like in the case of Brazil, where the legislators say, okay, yes, you will be the AI authority. Do you see, for instance, the ANPD with the sufficient resources and capacity to take on this task?
Yeah, there are some DPA authorities that has more budget and more funding than others in Latin America. So it depends on each country. The problem with that is that they will need budget and they will need employees and people with capacity to deal with their systems. And I'm not going to speak about any specific case of Latin America, but you know that the transplant of the model of the European model of data privacy to Latin America was not easy in terms of just making a copy and paste of ideas and make them work.
Mhm.
EU DPAs are much well funded and with employees with a lot of capacities and work and long-time story dealing with data protection. In the case of Latin America, several DPAs started from scratch, from zero, with no knowledge, and they are building everything. And we have to admit that in Latin America, data protection is not a priority for any government. In fact, in some cases, government has closed DPAs. So it's important to understand that it's not easy for DPAs to take the hat of AI and enforce it easily. Having said that, I remember that 2 years ago, the Red Iberoamericana de Protección de Datos did a coordinated enforcement against several AI companies, and they sent the same questionnaire, which was basically a request for information only, but could be transformed in a full investigation, like the one happened in Italy with OpenAI. So they are working together, and that's easier for them because they can share information. But but still, I think there's a long overdue problem with EPAs being correctly funded in Latin America.
Yes.
So
Yes.
taking the hat of AI will be difficult for them. But also creating a new AI agency is problematic because some governments may give it priority, other governments won't put the resources for them to work accordingly.
Yes, absolutely. And I was just as you were saying this, remembering I was reading the report from this like implementing commission that was created in Chile for the implementation of their new data protection law, which I believe will come into effect next year.
Yes.
Yeah, the beginning of next year.
Right.
And one of the main concerns were specifically this, like the training and well, the capacity in general, but the necessary for more budget of the authority. And I'm not quite sure. I will have to go back to the blog post, but I believe in Chile's proposal, the AI bill, they are also considering the Data Protection Authority as the authority of AI. So that would be definitely interesting, and it will create, of course, some challenges. But and this is my personal opinion, I do see or I do sense that DPAs are generally equipped
Yeah.
in a way to tackle at least some part of that regulation as it touches or as it pertains to the protection of personal data for sure. So moving on, because I know we have limited time,
Yeah.
just the last topic that I wanted to touch upon is the inclusion of some very lengthy provisions in this bills that allow for the creation of testing environments and regulatory sandboxes and other provisions that include like some sort of incentives for innovation. And I found this particularly interesting because on the one hand, like these proposals seem to be very like human rights and principle based, but at the same time, and like very pro human rights and protection, and in a way regulating these systems through this risk-based approach, but at the same time, like incentivizing a lot of their creation and innovating in this space, with some of them even creating like national programs for their creation right there, like to have um, how would I say, like national AI systems, which I found very, very interesting. So what do you think, Pablo? Do you think this is feasible? Do you think
Yes.
this? Mhm.
I think the approach is very positive because, as you said, not only you have to regulate and protect people, but also you need to encourage developing of AI systems at the national level or foreign or local. And sandboxes are a very good example of the government helping companies to try new things and see how they works without the overregulation that it means starting from zero with super regulation. So I think it's very positive. I do hope that works. And also one other thing that I saw in some bills is the issue of education and coordination with other stakeholders. For example, the Colombia approved a law about deepfakes, regulating AI creation of deepfakes in the criminal code. But they also have a provision for the Attorney General of Colombia to be involved in educating schools and people on the use of AI and not using it to harm. And that's very positive also because we need to learn that AI is good for certain things, but could be bad for other things.
Yes, absolutely. And we have seen um, especially DPAs, right, being very active in this space. So for instance, Brazil, and I believe only Brazil and Colombia have implemented regulatory sandboxes that touch upon AI. And more specifically, the one in Brazil, it was on data protection and AI. So definitely very interesting. And this, of course, create that safe space for the companies to innovate, but at the same time, and to test their technologies, but at the same time, it provides a lot of feedback for regulators as well on how to better understand and regulate these technologies. So I believe we don't have any questions from the audience, I would invite if there are any questions. We have 1 minute left. And okay, we're seeing no questions so far. And so I believe we are in time, and I just want to wrap up by thanking you again, Pablo. I don't know if you want to provide like some sort of final thought or reflection.
No, I think that we are on the early stages of regulating AI in Latin America, so it's good to hear and to see how things are developing. And I do hope that both data privacy and this new AI regulation will work together and be able to put some kind of clear path for companies to operate.
We do have a last minute question. It says, besides national initiatives, are you aware of some regional, for instance, Mercosur, or bilateral initiative related to AI, not necessary to regulate it, but to promote it?
I haven't seen anything in Mercosur at the Mercosur level.
Mm-hmm. Yeah, I haven't seen anyone, any from Mercosur specifically, but perhaps some of the initiatives that are relevant to keep in mind are the ones that were deployed in the context of the Ibero-American network that you were mentioning, Pablo. So, for instance, these investigations into some of the main AI companies, and I believe in their last annual meeting, they also set AI regulation as some of like their top priorities. So I believe like following more closely what the network is doing, it will provide some sort of idea into how the region is understanding this.
Yes, they have created a working group.
A working group for AI in particular, or?
Yeah, a working group on AI and data protection at the Ibero-American
Okay.
network. So they have specific working group for that.
Yes, definitely some work there to follow. Okay, so we are unfortunately out of. Okay, a last question for you, Pablo. What is Pablo's favorite AI regulation so far?
Oh, okay. I know that's a very difficult question. Coming from Ismael, I know him, so I don't know really. I think for the moment, I'm happy to see that deep fake regulation is coming out because it's very serious. It has an important impact in the electoral process and in young people, especially young girls. So it's important to start with deep fakes probably, which is already, there are a lot of bills about that, and also some countries already make it a crime.
Yes. Perfect. Okay. Well, I don't want to keep anyone else waiting. Thank you so much again, Pablo, for joining us. It's been incredible to have you. I hope you all
Thank you,
guys
Maria.
enjoyed the discussion. And if you're interested in learning more about these proposals, please go ahead and click on the link. I believe the blog post was shared in the chat. We also create a nice summarized table of our findings. So again, I would just welcome you all to take a look at the blog post and stay in the look for how these proposals are moving in the region. Thank you so much, and happy Friday to everyone. Bye-bye.
Bye bye.